Good morning, madam. Today we will be presenting on Contract Law 1. We are from L2T11 Group C. I'm the group leader, Chua Yiwen, and these are all my group members.
My name is Wang Yijian.
My name is Serene.
My name is Xuan En.
My name is Teo Jawan.
So there are four main purposes for our presentation. First, we aim to demonstrate a solid understanding of contract law principles and apply them to real-life situations. Second, we will examine the essential elements of a valid contract, including offer, acceptance, consideration, and the intention to create legal relations. Third, we will evaluate specific doctrines such as unilateral contracts, priority of contract, family agreements, scholarship agreements, counter-offers, and the terminations of offers. Finally, based on our analysis, we will provide reasoned legal advice and possible solution for the parties involved. Now I will pass it to Jawan to begin with the first issue.
My name is Teo Jawan, and I will be discussing on the first issue arising from the given facts. Cepat Sihat Sdn Bhd advertised a 10,000 ringgit reward for users of Immuni Patch who comply with instructions but still develop a severe allergy. ADA fulfilled the conditions, but the company refused to pay, arguing that the advertisement was merely promotional. The issue arose is whether the advertisement was a valid offer or merely an invitation to trade, therefore whether a binding contract arose between the company and AIDA. Section 2A of Contracts Act 1950 provides that when a person expressly willingness to do or abstain from doing something with the intention of obtaining that other person's assent, he is said to make a proposal. In the fact given, Cepat Sihat Sdn Bhd's advertisement expressly promised 10,000 ringgit to anyone who used the Immuni Patch as directed and still develop a severe allergy shows a clear willingness to be legally bound. This shows an intention to obtain the customer's assent, making it a valid offer. Next, Section 8 of Contract Act provides that acceptance occurs when a person performs the conditions stated in the proposal or when they accept the consideration for a reciprocal promise offered with the proposal. Based on the facts, AIDA accepted the unilateral offer of Cepat Sihat Sdn Bhd by performance that fulfilled the conditions as stated in the advertisement, which she bought the Immuni Patch and used it daily for 30 days as directed. Besides, Section 9 of Contract Act states that when a proposal or acceptance of a promise is made using words, the promise is said to be expressed. When a proposal or acceptance is made in a manner other than words, the promise is said to be implied. Based on the facts, AIDA accepted the unilateral contract impliedly by conduct of the directions stated in the advertisement rather than communicate acceptance in word. Thus, no communication of acceptance was required. In Carlyle and Cumberland Smoke Ball Company, the company advertised that anyone who used their smoke ball 3 times daily for 2 weeks as directed and still contracted influenza would be paid £100. It stated that £1,000 had been deposited with a bank to show their sincerity. Mrs. Carlyle bought the smoke ball and used as required but caught influenza. The plaintiff claimed for the reward. The company argued that the advertisement was a mere path and was not intended to create legal relations. The court held that the advertisement was a unilateral offer made to the whole world at large, accepted by performance when Mrs. Carlyle used the smoke ball as directed. Consideration was present when Mrs. Carlyle purchased and used the products, which benefited the company by promoting sales. Accordingly, a valid contract was formed and the company were bound to pay the reward. Applying to the facts, Cepat Sihat Sdn Bhd similarly advertised that 10,000 ringgit will be paid to customer users the Immuni Patch as directed and still develop severe allergy. It also stated that 100,000 ringgit has been deposited with June Bank to prove their sincerity. AIDA performed the required acts but still developed a serious allergy rash. As in Carlyle's case, the advertisement was a promise made in exchange for an act, creating a unilateral contract. Considerations exist when AIDA purchased and used the product, which benefited the company by promoting sales. AIDA's performance was an acceptance of the contract. Thus, company was bound to pay the reward. Furthermore, in Bowerman and another, an Association of British Travel Agent Limited (ABTA), the plaintiff booked a ski trip with an ABTA member, which later became insolvent. ABTA's notice promised a reimbursement, but it refused to cover the insurance premium. The plaintiff claimed the notice was a contractual offer. Accepted on booking, The court held that the notice was merely informational and lacked clear promissory intent to create legal relations. An advertisement or public notice is an offer only if it contains clear promissory intent to create legal relation. Otherwise, it is merely an invitation to trade. Unlike Bower's case, Trapasia Sendirian Berhad's advertisement used clear promissory language by stated that the 10,000 ringgit will pay to anyone that uses the Immunipatch as directed and still develops severe allergy and show intention to create legal relation by deposited 100,000 ringgit with June Bank to prove their sincerity. Therefore, there was a contract arose between the company and Ida. From the company perspective, it may argue that the advertisement was merely a promotional gimmick or an invitation to trade. Nevertheless, this argument is weak given the explicit reward, precise conditions, and objective evidence of contractual intention. In conclusion, the advertisement constituted a valid unilateral offer. Ida accepted the offers by performance. A binding contract was formed and the company is legally bound to pay Ida the 10,000 ringgit reward. As a possible solution, Trapasia Sendirian Berhad should honor the payment to avoid legal liability. In future, the company should clearly include disclaimers or limitations in its advertisement if it does not intend to be legally bound. Conversely, Ada may enforce her contractual right by claiming the reward as she has fully complied with the stated conditions. That's all for me. I'll now pass the floor to Yi Jian.
Thank you, Jiawen. Now, my name is Yijian, and I'll be talking about the second issue. The second issue is whether the consideration can move from the promisee or the third party, Ida and Hafiz. In the English position, in the case of Tweedle against Atkinson, John Tweedle married the daughter of William Guy. After the marriage, John Tweedle's father and William Guy entered into a written agreement in which each father promised to pay a sum of money to John Tweedle, which is the groom. Before any payment was made, both fathers passed away, and John Tweedle then brought an action against William Guy's executor, Atkinson, to recover the promised sum. The issue before the court was whether John Tweedle, who was not a party to the contract and had provided no consideration, could enforce the agreement. The court held that John Tweedle could not enforce the contract. This was because he had not provided any consideration for the promise. The agreement was strictly between the two fathers, and the consideration moved only between them. Under English law, consideration must move from the promisee and the third party, even if intended to benefit from the contract, and cannot enforce it. The application is that, based on the situation above, Ida's father, Rahman, and his friend, Johan, had entered into an agreement. Both men agreed that if their children marry each other, each of them would pay Rm 50,000 to the couple as a wedding gift. After the marriage of Hafiz and Ida, Rahman fulfilled his promise, but Johan suddenly died before making the payment. Hafiz and Ida then tried to claim for Rm 50,000 from Johan's estate, arguing that the consideration may move to him. Johan's executor refused, arguing that they were not parties in the contract. There is a high probability that the court would not hold that Hafiz and Ida can enforce the contract, as they provided no consideration and were not parties to the agreement. This case therefore establishes the English position that English consideration must move from the promisee and cannot flow from a third party. Now, the Malaysian position. However, there is a conflicting view with English common law position. The Malaysian position departs from the strict English rule, Section 2D of the Contract Act 1950, provides that consideration may move from the promisee or another person. As such, Malaysian law recognizes that consideration need not come from the person enforcing the promise. The application is that, in this present case, the agreement was made between Rahman and Johan, whereby each promised to give Rm 50,000 to the couple if their children, Ida and Hafiz, marry each other. Although Ida and Hafiz themselves did not provide any consideration, the consideration flowed from the mutual promise exchanged between Rahman and Johan. Under Malaysian law, this is sufficient to constitute a valid consideration. The fact that the consideration did not personally from Aida and Hafiz agreement under Section 2D of the Contract Act 1950. In conclusion, unlike the English position in Tweedle against Atkinson, Malaysian law allows consideration to move from the promisee or third party. Therefore, the requirement of consideration is satisfied under Malaysian law, which allows consideration to move from a third party, enabling Hafiz and Aida to enforce the agreement. The possible solution is that they should rely on the Malaysian position, as this is a Malaysian scenario, which allows consideration to move from a third party and may enable Hafiz and Aida to enforce the agreement. The executor of Johan's estate may consider offering a settlement to avoid lengthy legal proceedings, while Hafiz and Aida, instead of pursuing court action, can accept a fair settlement to secure a guaranteed outcome and resolve the matter efficiently. That's all from me, and I will pass on to Serene. Thank you.
Thank you, Yijian. My name is Serene, and now I would like to illustrate about the third situation from the text given. From the text given, Aida, who was struggling for her financial problem because of her mother, broke the promise and intended saying that family arrangements are not contracts. So the issue arose for this situation was whether there is an intention to create a legal relation between Aida and her mother in family's relationship. So in this case, we can look into two cases which are related with this situation, which are Jones against Padawatan and Pyong Kon against Chong Chai Fa. First of all, in the case of Jones against Padawatan, a mother persuaded her daughter to leave her job in the USA and come to England to study for the bar. The mother at first promised to pay a monthly allowance for maintenance. Later, the mother bought a house for the daughter to live in and rent out rooms. After this agreement, the mother started to sub possession of the house. So the issue of this case is whether the mother's promise to maintain the daughter constituted a legally binding contract. The Court of Appeal eventually held that the arrangement was a family agreement, so there was no intention to create legal relation. Therefore, the agreement was not really enforceable. Based on the situation, the daughter was encouraged to leave employment to pursue for her professional studies. Therefore, a monthly allowance was merely provided for her for support when she is studying. The promise made by Aida's mother was a domestic agreement and lacking intention to create legal relation and is thus unenforceable. Secondly, we can look into the case of Pyong Kon against Chon Chai Fa, a Malaysian case about the domestic agreement as well. In this case, a woman, Jong Shit Song, died by owning several properties, including the land in dispute. From her first marriage, she had 2 children and one of them was the respondent, which is a son. She then married to the opulent, but the marriage was actually never legal registered yet. So the respondent executed a document relating to the disputed land. The opulent therefore claimed actually this document was a transfer of ownership to him. The respondent argued that it was only meant to grant the opulent of a life interest, not ownership. The issue arose in this case is whether the document amounted to legally binding agreement transferring ownership or merely a family agreement lacking of enforceability. The court held that the document was executed out of family consideration, not commercial intent. Therefore, the parties did not intend to enter into a legally enforceable contract. Relate back to the situation, Aida's mother initially promised her to provide a monthly allowance of 2,000 ringgit per month until she graduated, but eventually stopped with the argument that family arrangements are not contract. It showed that the agreement between Aida and her mother was made within a family relationship, and the agreed allowance merely parental support, not commercial gain. There is no evidence that the parties intended to enter into a legally binding contract. Thus, it shows that it's not a legally enforceable contract between them. From the application above, we can get the conclusion that there is no legal intention or legal enforcement for the agreement between Aida and her mother due to it is a domestic agreement rather than a legally binding contract. In short, Aida is unlikely to say that is succeed in enforcing the promise as a contract. However, Aida's stand is credible but not guaranteed claim. This is because although her presumption against legal intention in family arrangement are not contract, but she may still succeed if she proved the objective intention to create the legal intention between she and her mother. On the other hand, even Aida's mother has a strong starting presumption in her favor, but actually her argument is weak because the promise was clear and the payments were made consistently before this. So there is a high risk for the mother if the court eventually find out the reliance-based enforceability of Ida rely on the allowance of her mother. In a nutshell, family arrangements are generally presumed not to be legally binding, but Ida still may successfully to rebut this presumption due to clear reliance and substantial financial sacrifice. Therefore, there is a reasonable possibility that the court will find the agreement legally enforceable, though the outcome is not guaranteed from my humble opinion. That's all from me. Now, I would like to pass the floor to the next presenter. Thank you.
Thank you, Serene. My name is Xuan En, and I will be discussing the four issues, which concern whether the scholarship agreement entered into between IDA and the Ministry of Health is valid and enforceable despite the absence of the consideration. Let us begin with the general rule. According to Section 26 of Contracts Act 1950, an agreement made without consideration is void. Based on the facts of the case, the scholarship agreement entered into between IDA and the Ministry of Health appeared to lack consideration on the part of IDA. In this case, the Ministry of Health promised to provide financial assistance for IDA under the 5-year government bond. However, IDA did not provide any immediate consideration or promise to the Ministry of Health in return for the financial assistance provided by the Ministry of Health to her. Therefore, according to the general rule under Section 36 of the Contract Act 1950, the scholarship agreement between IDA and the Ministry of Health would be regarded as void for the lack of consideration, since the general rule is that an agreement made without consideration is void. However, there is a specific exception for the scholarship agreement. Under Section 4, subsection C of the Contracts Amendment Act 1976, no scholarship agreement shall be invalidated on the ground that such agreement lacked consideration. Based on the facts of the case, IDA accepted a scholarship from the Ministry of Health to support her study. The financial assistance was provided under a 5-year government scholarship bond. However, IDA resigned to work overseas after only 2 years, thereby failing to comply with the contractual obligation under the scholarship bond, although she argued that the terms were unfair and constitute a penalty and that she has not provided any consideration at the time the agreement was formed. Nevertheless, under Section 4, subsection C of the Contracts Amendment Act 1976, no scholarship agreement shall be invalidated on the basis that such agreement lacked consideration. Therefore, the scholarship agreement entered into between IDA and the Ministry of Health is said to be valid and enforceable despite the absence of consideration. To support this principle, we can refer to the case of University of Malaya and Lee Ming Chong. In this case, the University of Malaya awarded Lee a scholarship under the Colombo Plan to pursue a master's degree in Canada, subject to a scholarship agreement requiring him to serve the university for at least 5 years upon his return. The agreement also stipulated that if he breached this obligation, he and his sureties would be liable to pay a fixed sum of $5,000. After completing his study, Lee was appointed assistant lecturer and later offered promotion to lecturer, but he resigned before completing the 5-year service period. He argued that the scholarship agreement was void for lack of consideration, that it was unenforceable, or that he has fulfilled the agreement through his service. The Court of Appeal held that the university was the principal party to the agreement, that the consideration existed because the scholarship itself constituted consideration for Lee promised to serve, and in any case, Section 4, subsection C of the Contracts Amendment Act 1976 ensures that scholarship agreements are valid even without consideration. Consequently, Lee was bound by the terms of the scholarship agreement and the university was entitled to enforce the repayment clause. Based on the facts of in this case, IDA received a government scholarship from the Ministry of Health to pursue full-time law study, and she was subjected to a 5-year service bond, but she argued that the agreement is not valid due to the absence of consideration on her part and refused to serve for the full 5 years. Similarly, in the case of Lee Ming Chong, the University of Malaya awarded a scholarship to Lee under a service bond requiring him to serve the university for 5 years. Lee contended that the scholarship agreement was void for lack of consideration and that he has already fulfilled the agreement through his service. The court then held that the scholarship itself constitutes consideration for his promise to serve, and in any case, Section 4, subsection C of the Contracts Amendment Act 1976 confirms that the scholarship agreement remained valid even without consideration. Applying the same principle, the Ministry of Health is entitled to enforce the scholarship bond against Ida as she resigned after only 2 years instead of completing the required 5-year service period. In conclusion, it is highly likely that the scholarship agreement between Ida and the Ministry of Health is valid and enforceable despite the absence of consideration on the part of Ida. Finally, for practical advice, Ida may consider negotiating with the Ministry of Health for a reduced repayment amount or repayment installment plan. Besides, she could also request a waiver of any interest or penalty imposed under the bond due to financial hardship. From the Ministry of Health's perspective, while it is legally entitled to strictly enforce the scholarship bond to protect public funds, it may also consider adopting a compassionate and flexible approach, such as allowing partial repayment or extended payment terms, in order to achieve a fair and practical resolution. This concludes my discussion on the fourth issue. Thank you.
Thank you, Shannon. I am Ewan. So moving on for the fifth issues, based on the above situation is whether there is a counter offer made by Ida, therefore the offer was not longer valid between Ida and Laila. There are three relevant authorities will be discussed in this situation, which are Section 7 Sub A of Contracts Act 1950, Height and Range, and Malayan Flour Mills Berhad and Saw Eng Chi, administrator of the estate of Saw Cheng Cho, deceased, and another. In general, according to Section 7 Sub A of Contracts Act 1950, the acceptance must be absolute and unqualified in order to convert a proposal into a promise. This means that an acceptance must be an unconditional assent to the terms proposed in the offer. Based on the situation above, Laila, a property agent, originally offered to sell the house for 500,000 to Ida, but Ida requested Laila to sell her for 450,000 ringgit. Later, Laila rejected it, but Ida suddenly changed her mind and wanted to accept the original offer. In this case, rejecting the original offer and proposing a new offer by Ida shows that original offer had not been accepted by Ida unconditionally. Therefore, the acceptance of Ida was not absolute and unqualified. However, there is an exception for within several cases. In the case of Height and Range, the defendant wrote to the plaintiff on June 6 offering to sell his farm for £1,000. The plaintiff immediately called on the defendant and offered to purchase the farm for £950, but it was later rejected by the defendant. On June 29, the plaintiff immediately wrote to the defendant to accept the earlier offer of £1,000. The court held that there was no binding contract because the plaintiff did not absolutely and unconditionally accept the defendant's offer price of £1,000. By proposing a different proposal of £950, the plaintiff had rejected the defendant's offer and now makes a new offer. This counter offer destroyed the original offer and he cannot now revive it by tendering a subsequent acceptance. Based on the situation above, Ida planned to buy a house in Seraman from Laila, a property agent. Laila initially offered to sell the house to Ida for 500,000, making Laila the original proposer and Ida the original acceptor. However, Ida did not accept this offer and instead proposed to purchase the house for 450,000 ringgit, which constituted a counter-offer. Ida argues there is a valid offer among them, but Laila disagrees with her. At this point, Ida became the new proposer and Laila the new acceptor. Also, when a counter-offer had been proposed, it means that the original offer had been destroyed. So Laila later rejected the counter-offer proposed by Ida. She cannot return back to the original offer, even if she so desired. Thus, there was no binding contract between them because Ida introduced the new terms of offer and did not unconditionally accepted the original offer, known as counter offer, had been rejected by Laila. Similarly, in the Malaysian case, Malayan Flour Mills Berhad and Saw Eng Chi, Saw Cheng Cho and Saw Eng Cheong were co-owners of a piece of land, lot 5020. On 12 January 1979, their solicitor sent a telex offering to sell lot 5020 to Malayan Flour Mills Berhad for 305,000 ringgit. On 15 January, negotiation took place about expanding the sale to include 3 additional adjoining lots for a total of 407,000 ringgit. Later, the plaintiff managing director decided to accept the original offer and enclosed of 47,000 as a deposit check, claiming a concluded contract. The court held that the plaintiff conduct by proposing to buy all 4 lots and introducing new terms amounted to a counteroffer, thereby destroying the original offer, and no valid contract arose from the original telex acceptance. In deciding whether there is a concluded contract in a given case, the court will examine all the circumstances. Based on the situation above, Aida planned to buy a house in Seremban from Laila, a property agent. Laila offered to sell the house for 500,000 ringgit, and Aida replied offering 450,000 ringgit. Later, Laila rejected the counter offer. A few days later, Aida changed her mind and wrote back that she agrees to buy at 500,000 ringgit. Laila refused to sell, saying the offer was no longer valid. So it is likely that the court will have the introduce of new terms of offering 450,000 ringgit for a house amounted to a counteroffer. The conclusion, the acceptance was not met absolutely and unconditionally. Introducing a new term into the proposal constituted as a counteroffer, which was a rejection of the original offer. Hence, the original offer was no longer valid and no binding contract was formed. The possible solution for Aida is submitting a new formal offer at 500,000 ringgit, possibly with incentive to Laila. On the other hand, Laila can reconsider Aida's new formal offer if it is still commercially beneficial and no new potential buyer exists. Next, she can specify that any counter offer will automatically destroy the original offer to avoid confusion next time. To sum up, for the first issue, the advertisement was an invalid offer, therefore there is a binding contract arose between the company and Aida. By relying on a Malaysian position, the consideration can move from the promisee or third party, Aida and Hafiz, for the second issue. There is no intention to create legal relation between Aida and her mother in family's relationship in third issue. The scholarship agreement entered between Aida and the Ministry of Health is valid and enforceable, despite the absence of consideration for the fourth issue. Last but not least, for the fifth issue, there's a counter offer made by Aida, therefore the offer was no longer valid between Aida and Laila. That's all from us. Thank you.